In news that we are breaking to you, the Supreme Court has pronounced its verdict on the case of those netas who have criminal charges against them. The Supreme Court has said that the charged persons in criminal cases cannot be disqualified from contesting polls. Meenakshi Bhanja is tracking this story for us. We'll go across to Meenakshi. Meenakshi, if you can hear me, we'll go across to Meenakshi in just a bit. But right now, that's the latest we are breaking to you. The Supreme Court has said that those netas who simply have charges against them cannot be disqualified. Now, this is in response to a petition that had asked the Supreme Court to disqualify those netas who have criminal charges against them. But now the Supreme Court said that those with charges cannot be disqualified. However, those convicted, as we know, cannot contest elections. Meenakshi joining us on the phone line with more information. Yes, Meenakshi, over to you.
Well, Afrida, this is hugely important news coming in from the Supreme Court. For starters, the Supreme Court Constitution Bench has ruled that charged persons in criminal cases cannot be disqualified from contesting polls. Now, this Constitution Bench judgment has had the potential to really change the things as they should. Remember, under the current provision of law, any person who is convicted can be debarred from contesting polls. Right. And this, by way of this plea, the petitioner was seeking for this bar to set in earlier. So that bar for now cannot set in earlier. That is the opinion of the Constitution Bench of the Supreme Court of India. This is the operative part that we are bringing to our viewers. Remember, Supreme Court has further added as to how the malignancy of criminalization of politics is not incurable. And the Supreme Court has agreed with the arguments advanced by the Attorney General that Parliament must make a law in this regard.
Right.
So this is the operative part that we are getting for our viewers at this juncture. The Supreme Court has declined to rule on the disqualification issue of candidates who are charged or charges are framed against them in a criminal case.
Right. Two important points that you made. One, of course, the fact that the bar cannot be set any earlier, which means that only the convicted netas can be debarred. Those who are facing charges cannot be debarred. Also, the Supreme Court has asked Parliament to make a law in this regard. Meenakshi, can you throw more light on what exactly does that mean? Does it mean that there needs to be legislation now passed even after this order?
Well, Afrida, essentially it means that the government, while the matter was being argued in the Supreme Court Constitution Bench, had fervently pleaded for the top court to keep its hands off the issue, told the Supreme Court that this is an area which is the function or falls within the realm of legislative lawmaking powers of the Government of India. Since the provision for disbarring candidates already exists under the RPA, and under the present provision of law, any candidate can be disqualified in a criminal case if he or she is convicted. So therefore, there was really no need to have an early ban be put in place by the Supreme Court, which is essentially what the petitioner was pleading in the Supreme Court. Now, what has been hugely interesting was the differing positions between the Election Commission of India and the Government of India. Both had taken separate positions on this one. The Election Commission had told the Supreme Court that it could go ahead and introduce more reforms if it felt that was the need of the hour. However, just moments back, the operative part of this judgment clearly points towards one thing, that the Supreme Court is declining to get into this area of introducing any further earlier ban on contesting polls. The Supreme Court is agreeing with the arguments made by the central government while the matter was being argued, that this is a function which is the prerogative of the Parliament to enact the law, to put in place an earlier ban for candidates with criminal antecedents.
Right. Very important there. Meenakshi telling us the Supreme Court has put the onus on the Parliament now to make a law in this regard. On its own part, it cannot disqualify those netas who have charges, criminal charges against it from contesting polls. Thanks for joining us.